morning. Welcome to Lawrizons News. I'm GN, your news reporter today. Let us look at the top topic reports today. Today's news will mainly report on the effects of marriage on status and property of non-Muslim married women. Husband and wife are usually regarded as one entity in the eye of law. The legal existence of the woman is suspended or incorporated into that of her husband during marriage. The wife loses her rights to her name, properties, and heritage. If the wife is indebted before marriage, she can evade the liabilities to pay for the debt after the marrying because it was the husband who would be responsible for the debt. However, she cannot bring actions in court in her own name, and she can sue in her husband's. She cannot be sued without making the husband the defendant. The husband will be liable for all the wrong the wife committed. However, she can be sued in a criminal proceeding without implicating the husband because their union is a civil union. In a tort claim, the husband and wife are not allowed to give evidence for or against each other. They are not allowed to sue each other because they are regarded as one entity in the eye of law. A wife battered by husband cannot initiate any proceedings to sue him. Moreover, there is no way a wife can sue her husband in a criminal proceeding. I will now pass the floor to our reporter today, Mr. Thaqib, to explain on the status of husband and wife in holding any property.
When a man and a woman have legally married, there are consequences to such marriage in terms of the personal status and property of the wife and the husband. In regard to personal status of the wife, Section 4, Section 4A, Section 6 of the Married Women Act 1957 and the relevant cases must be examined. Section 4 of the Act provides that a married woman is capable of Subsection 1, she can be acquiring, holding and disposing any property. Subsection 2, she can be liable in tort, breach of contract, debt or obligation. Subsection 3, she can sue and being sued in her own name in tort or contract and shall be entitled to remedies and redress for all purposes. And subsection 4, she can be subjected to the law relating to the bankruptcy and to the enforcement of judgment and orders. And further mentioned in the last limb of the provision, this capacity of married woman is deemed to be treated as if she were a film soul, but the only thing that changed is her status, which changed from single to married woman. Next, the ability of the spouse to hold another as liable in tort for injuries suffered must also be discussed. So the old legal position of this matter is illustrated in the case of Farida against Muhammad Habibullah. So in this case, the Supreme Court ruled that the wife could not bring cautious actions against her husband for assault and battery because of the restriction under Section 9, Subsection 2 of Married Women Ordinance. However, such restriction was lifted by the repeal of Section 9, Subsection 2 with Section 4A in 1994. Therefore, Section 4A of the Act is our latest legal position, enabling a spouse to sue each other in tort for injuries suffered as if they were two separate individuals. So here, the husband and wife share the same capacity of tortiously liable to each other in respect to the tortious act inflicted between them. So the injuries suffered due to the spouse tortious act include mental injuries as laid down in Wilkinson against Downton, quoted by the case of Yo B. Lin against Lee Eun Chi. So the court in Yo B's case viewed that excluding mental injuries in the word injuries in the present case is no longer relevant unless expressly provided in the legislation. Dear Sinto people, there are noticeable differences in the effect of marriage to the wife and husband in Malaysia as compared to the common law. So in common law, husband and wife are regarded as one entity, holding the husband liable in this wife's conduct or obligation, restricting the spouses to sue each other. Meanwhile, in Malaysia, husband and wife are regarded as separate individuals, as mentioned in Section 4A of Married Women Act 1957, allowing the spouses to sue each other. For the second difference, in common law, husband shall be liable for his wife's act and obligation. Meanwhile, in Malaysia, Husband shall not be liable for his wife's conduct or obligation pursuant to Section 6, subsection A of the Act. For the last difference, the wife in common law can only sue and be sued under her husband's name, while in Malaysia, the husband has no place in the wife's legal suit stipulated under Section 6, subsection B of the Married Women Act 1957. So here, common law principles were removed from our Married Women Act 1957, and as a result, we can see that the amendment does favour the husband's interest by legally holding his capacity as being free from the consequences of his wife's unlawful act compared to common law. So in our view, Malaysia's approach serves the justice better, as there is a clear liability of both husband and wife to their own conduct or obligations. That's all from me. Over to you, Hui Wen. Thank you.
Thank you, Thaqib. With that, we shall move on to the next highlight for today. I am Lim Hooi Wen, and we will discuss the effect of marriage on the property of married women. According to Section 5 of Married Women Act 1957, regardless before or after the date of coming into force of this act, the property belonging to the married woman or was held for her separate use in equity will remain as her property as if she were a fiancée. Any agreement executed on or after the date of the Act's enactment is void if it purports to attach any restriction on anticipation or alienation to a woman's enjoyment of property that could not have been attached to a man's enjoyment of such property. In short, in pursuant to Section 5, the property which belonged to a woman will still be her property and may be disposed accordingly, and the restrictions on anticipation or alienation were clearly stated. It was also shown in the case of Lau Cheng Eng against Lau Boon Kian and others. Pursuant to Section 5, a married woman holds her property as if she were a fiancée. Therefore, a husband does not have the authority to compromise the wife's right and interest simply for being her husband. Moving on to next, Section 8. The Act discusses the status of gifts by the husband to wife. Property transferred to the wife as a gift shall be deemed invalid as against the creditor if after the gift was made, the property continues to be in the disposition of the husband, or any investment of monies made by the husband but in the wife's name without the knowledge of the creditors. However, the money may be followed as if it belonged to the husband. In short, the properties will remain as the husband's property. The protection and security of property is also laid down in Section 9 of Married Women Act. Married women have the right to sue their husband in their own name to seek for the same remedies and redress for the protection and security of property as if such property belonged to her as a fiancée. Besides, the spouse may also sue each other in tort in order to protect and secure their property. Subsection 3 also provides that it is adequate to allege that a married woman's property is her property in any criminal case or other procedure involving her property. Now, I would like to pass the floor to Ahmad. Thank you.
Good morning, Sinto. I'm Ahmad. I will now explain regarding the wife's antenuptial debts and liabilities. Under Section 10, Clause 1 of the Marriage Women Act 1957, a woman after her marriage shall continue to be liable for all debts contracted and all contracts entered into or wrongs committed by her before her marriage, including any sums for which she is liable as a contributory, either before or after she has been placed on the list of contributions under and by virtue of any written law relating to joint stock companies. Besides, Section 10, Clause 2 of the Marriage Women Act 1957 illustrates that women as such may be sued for any such debt and for any liability in damages or otherwise under any such contract or in respect of any such wrong. Moving on, Questions between husband and wife as to property to be decided also will be discussed. Section 11 of the Marriage Women Act 1957 provides that in any question between husband and wife in relation to title or possession of property, either party may apply to any judge of the High Court or Session Court. In addition, married women also act as an executrix or trustee. Section 12 of the Marriage Women Act 1957 states that a married woman may sue or be sued if she is an executrix or a trustee alone or jointly with any other person as if she were a firm sole. Besides, in this act, according to Section 13 of the Marriage Women Act 1957, nothing other than Section 5 Clause 2 can affect the existing or future settlements regardless before or after the marriage, provided that it is the property of the married woman. Lastly, Section 15 discusses the saving of married women. It provides that the rights and obligations of married women in the states of Johor, Kedah, Kelantan, Negeri Sembilan, Pahang, Perak, Perlis, Selangor, Terengganu, and the Federal Territory of Kuala Lumpur will not be affected by civil law, and Muslims married women were bound by this law, however subject to Islamic law. Lastly, we will explain the criminal charges against a wife or husband pertaining to remedies of married women for protection and security of separate property. There are three situations in relation to criminal proceedings against a husband or a wife under Section 4 of the Marriage Women Act 1957. Firstly, when the husband and wife are living together, no criminal proceedings may be taken by any of the spouses. Secondly, when the husband and wife are living apart, but the act complaint of occurred when they were living together, no criminal proceedings may be taken by any of the spouses as well. Thirdly, when the husband or wife is leaving or deserting or about to leave or desert the other spouse, criminal proceedings may be taken against the offending spouse. Thank you. Next, I will pass the floor to Ammie.
Thank you, Kaiman, and hello, Sinto. My name is Ammie Syazlene binti Muhammad Zamri, and I'll be reporting on the opinions and conclusion of today's news. As our main reporter has explained just now, the crucial effect that can be seen when we remove the common law principles from our Married Women Act 1957 is that the amendment favors the husband's interest by legally holding his status as being free from the consequences of his wife's unlawful act and vice versa. In our opinion, this amendment is reasonable as one must not be liable for someone else's mistake, even though they are husband and wife. Here, we can say that Malaysia's approach serves the justice better as there is a clear liability to both husband and wife to their own conduct and obligation. Looking at all the provisions explained by the other reporters previously, we can see that Malaysia takes care of the relationship between the husband and the wife by making them accountable of their own mistake and not bring their spouse into the problem caused by any of them. We can also see how Malaysia holds women to the same level as men in terms of status and property. To conclude our news, can clearly see how Malaysia maintains the peace and justice in a marital relationship by not allowing the wife or the husband to take any legal action, be it criminal charges against each other. All problems faced alone or together in a household should be resolved in a good way by bringing the case to the court and let the judge serve justice to both parties.
Thank you for watching UUM Lawrizons News. We hope you have a nice day and see you tomorrow at 8 a.m.